Hey, folks. I'm Elijah Ford, attorney at law and managing partner at Atlas Law, and I'm bringing you All You Gotta Do Is, your resource for navigating life's little legal mysteries. Stay tuned and let's make the system make sense. Welcome back to another episode of All You Gotta Do Is. Today, we're going to be talking about the great beyond. No, just kidding. We're going to be talking about trust and estates, though, which is pretty close. And I have with me here a special guest. This person I've known for a long time, haven't seen for an equally long time. She actually used to be one of my mentees when she was in law school, and here she is, all graduated and trained up. Darcel, do you want to introduce yourself to the folks?
Yeah, hi, I'm Darcel Lobo. I own DAL Law Firm in Normandy Park, just a little bit by the airport. Been practicing 15 years now. I help my clients with estate planning, real estate, and bankruptcy, really helping them to plan for their financial future. I've been practicing 15 years, and it has been a while. I'm glad to be back, glad to see you, and look forward to today's podcast.
All right. Well, as always, we're going to start with class in session and, just talk about some background for wills, for trusts and estates. And normally for this section, things normally trace back to England and like the Norman invasion, but today we're going to go even further back and we're talking about Rome and the ancient times, the before times. So ancient Roman law, for instance, allowed citizens, and when I say citizens, that means something specific. That means men who were not enslaved, to establish trusts by will to hold property for their descendants. And these trusts only became effective after death. And then, these trusts evolved. And by the Middle Ages, lawyers were involved, and their clients wanted trusts, sometimes to allow the church to use and enjoy land legally. And also, and this I found really interesting, and I wish that trusts were explained this way to me in law school because I would have paid more attention. But crusading knights apparently were a big part of the push for the development of trust law in the Middle Ages. And so these knights would go off on their crusades, and while they were gone, they would appoint other people to sort of be in charge, manage their lands while they were gone. But their intention was to retain the ownership of the land, but just have someone sort of take care of it in their absence. So assuming they didn't got out there on the crusades and they made it home, they would come home and then find that the person that they put in charge of managing their land was now staking claim to it. And so then obviously the courts had to become involved because what needed to happen was the ownership of the land and the usage of the land had to be separated out. Before, it was one and the same. That there was no separate. If you used the land and you owned it, versus there's someone who can have ownership of the land and also free use and enjoyment, quote unquote, enjoyment of the land. So the court started to separate those rights out to allow for things to be held in trust. So someone could own a thing and then someone else would still be in charge of managing that thing, that asset for them. So we've been sort of on that trajectory since. So from the ancient times to the Middle Ages to now, what we have is we've come further along that road, but with some key differences. So in the Middle Ages in mainland Europe, a lot of it was was gender driven. So in many cases, women could not inherit and hold property on their own. So that's a very key difference now. Thank you for that. Gender parity is good. And then also, we don't have church courts or ecclesial courts. I can never get my mouth around to pronouncing that. So now everything in America at this point in the United States is all civil. The courts, the church is not involved, and gender is not an issue. And but one of the key things that we have carried over all the way back actually from ancient times is the fiduciary duty. And that is a big part of what allows a trust to happen. So the fiduciary duty, I mean, it goes back to the Magna Carta, and before that to ancient times. We can find a fiduciary duty as far back as the Code of Hammurabi in 17th century BCE. So that's before the Common Era, or before Christ, for for those of us who want that demarcation. So the and I think that probably, Darcel, you're going to talk a little bit more about what a fiduciary duty is. So I won't go too far into that now, but the point is that this modern concept is based on a very ancient principle that has been, adapted over the ages for our modern times and our modern situations. So now what we have are trusts that can be used to expedite the transfer of property to beneficiaries. Um, Trusts can be used to substantially lower an estate tax bill. Trusts are also now used to allow for the care, education, and maintenance of spouses and children after a wage earner's death. And they're just generally useful in estate planning, and for care and maintenance of dependents. So that was trusts. And now wills, it's it's a different beast. Um, but still kind of the same history. We can trace the first use of a will back to ancient Greece and Rome. And these documents, again, were used to transfer possessions between deceased male citizens and their heirs, also male citizens. And the process of creating the will, though, was pretty similar to what we see today. The person has to be of sound body and mind, and the will required witnesses and signatures. Um, and I don't want to just leave people with the impression that ancient Rome and Greece and sort of the ancient white places were the only people using wills. We can look back to other ancient texts, including the Quran, and there are mentions of wills even as far back as that in those sort of non-European centers. So we've been, as humans, wanting to reach beyond the grave and influence the living in one way or another, either because we want to take care of them, or but because we're control freaks and we want to make sure that things happen a certain way in the future. And wills and trusts have continued to be instruments for that. So wills, again, like trusts, have changed over time to account for and accommodate for differences in family structures, customs, and legal systems. So, I mean, the purpose of the will has pretty much stayed the same, but again, like with the gender, that's another one. Now we can will things to people regardless of their gender, like in England, and I can't remember exactly when this changed, but it used to be that the first born son would get everything. And if you didn't have a son, then it would have to go to that next, like, most senior male relative, and women would be completely cut out. So thankfully, that has changed. But yeah, so what hasn't changed, though, is that wills and trusts are important. And I would say that more people should have them than currently have them. So let's dig into that right now.
Yeah.
Let's talk about that. Let's talk about why someone would need an estate plan or a trust or any one of these other instruments.
Yeah, well, I tell my excuse me, everybody needs to have an estate plan in place. It doesn't have to be complex. It doesn't have to depend on how much assets you have. It doesn't have to be something that's overly complicated or overly expensive, but we're all going to pass away at some point. And we all want to ensure that, whatever assets we have acquired, whatever you worked hard during your lifetime to acquire, you want to ensure that it's distributed to the people that you want it to be distributed to and not decided by someone who doesn't know you. Because if you don't have a plan in place, a judge is going to decide where that goes and who's in charge. And there is a state, Washington State has an estate plan for you if you don't have one already prepared, but it may not be what you want. And the process for that to be achieved is usually not ideal. And so it's important for everyone, excuse me, to have an estate plan in place, whether it's a will or a trust. And again, they don't have to be complicated, but I tell all my clients, leaving an estate plan in place, having a will, having a trust, having some kind of plan in place is the best gift you can leave to your family, to your loved ones. Because at a time when they're grieving the loss of a loved one, to then have all these legal problems on top of that, you're leaving a large burden on your loved ones if you don't have a plan in place. And so it's just very important that there is a plan in place. Do we want to talk about wills and trusts? And,
Yeah, so when you said estate planning, what I understood you to mean is that estate planning is like an umbrella term, and there are different components within that.
Correct.
So can you tell us about, like, what is an estate plan?
Yeah. So an estate plan, primarily it focuses on what happens upon your passing away. And so that's going to be where your will comes into place. That's going to be where a trust comes into place. There's other things as well, like making sure all your beneficiaries are updated on your life insurance policies, on your retirement plans, on your bank accounts, any kind of financial asset, making sure that those beneficiaries are updated. But in addition, an estate plan also should provide for what happens if you're unable to make your own decisions. So while you're still living, but maybe there's a short-term ailment or an accident or something long-term we see with Alzheimer's or dementia, that we need to have what's called a power of attorney in place where you name someone to make decisions for you and to handle your affairs while you're still living, but you're unable to do so. So it's making a plan now for in the event that you're unable to make your own decisions, because waiting until you need to have it in place is usually too late. If you wait until, you have the dementia, until you have Alzheimer's, you don't have competency to sign those documents or understand them. So it's too late. So we want to make sure we have something in place before you actually need it. But the options inside that umbrella of estate planning, there's quite a few options there. And it's going to depend case by case on, what assets you have, what the family dynamics are, what your intentions are. But there's a lot of options for you. And in Washington State, we have various options as well when it comes to real estate and how to transfer that. So it's a comprehensive term that just means putting together a plan for in the event that you pass away or you're unable to make decisions for yourself.
Okay. So you talked about a few different components. Let's go ahead and break those down a little bit. So we talked about the sort of the history and the development of trusts earlier. Can you talk to us about trusts today? Like, well, listen, I know prior to becoming an attorney, when I hear like, oh, trust, or someone's a trust fund baby, I think that is the province of the 1%, the rich, the elite.
Right.
An average income earner, do they need a trust? So can you talk to us a little bit about that? Like, what is a trust and who would need a trust or who would benefit from a trust?
Yeah. So both your will and your trust are going to be the plans for what happens upon your passing away. But let's talk about the differences between the two, because both options are vehicles to reach the same goal. We can get to the same end result with both options. It's just a question of how are we going to get there. So a will is a set of instructions of what you want to have happen upon your passing. But in order for it to happen, it has to go through probate, which is a whole conversation in and of itself. But probate is a court process where a judge oversees the administration of your estate according to the terms of the will and ensures that the will is followed based on what you've provided in your will. Versus a trust, you create that now. You are your own trustee of your own trust during your lifetime, but you have named someone as your successor trustee. So that upon your incapacity or upon your passing, that person that you named takes over your trust and makes distributions according to the terms of that trust. It does not have to go through probate. There's no court involvement. There's no court oversight of that process. And so that trustee you've named can make the distributions according to the terms of your trust, just like, so it's similar to a will in that you still have the same net distributions. It's just how are we going to get there? And so usually there's a few pros and cons on the two options. So for some clients, they prefer the will because it is less expensive to set up, but they are going to have probate costs on the back end, versus a trust, which can be more expensive to set up, but you don't have the probate costs in the back end. So once you factor in probate costs, the trust ends up being a less expensive option, but initially out of pocket, the will is going to be a less expensive option. If I have a client who owns real estate here in Washington and also maybe has property in a different state, I highly recommend a trust because, or else they're looking at probates in each state where they own property. Some of my clients will have a second home, maybe in Arizona or California, or maybe they've inherited some property out of state. So if they have property in more than one state, I highly recommend the trust because, again, you don't have multiple probates occurring in different states where you own the various real estate.
Yeah, and makes a lot of sense.
Yeah, and then also with trust, the trust gives you more privacy. So the will gets filed with the court. It is public record. Everyone can see what your estate included. It can see who the heirs are, who received what your debts were. And some clients really want privacy. That's important to them. And so with the trust, it's not filed with the court. It's not public record. And so they have more privacy in the trust. So they prefer it for that reason. With either option, you have full and complete control. You can make changes at any point in time, whether it's the will or the trust. If you want to make any amendments, you can do so.
So I have a few questions.
That was a long answer.
No, it's great. It's great. I have a few follow-up questions on that, though. Are there certain things that you can do with a trust and not a will, or vice versa? Or are there some things that you just can't do at all? So let's say, again, wanting to be the hand reaching out from the grave, which is how my law school professor always explained these things. But let's say, and I, for the record, I don't want to do this, but let's say that I did, hypothetically, I wanted to reach my hand from out the grave and say to my daughter, I'm going to give you X amount of money, provided that you get married. Like, are there certain things that could I do that? Like, is that an appropriate thing or a possible thing to work into a trust or a will?
So yes, you can do it with both options. So when I talk about a will or a trust, I'm referring to what's called a revocable living trust. But there are different types of trusts. So within a will or within a revocable living trust, you can have trust within it. And so one of those can be a trust for minors. There could be a special needs trust. There could be various types of trusts within your trust or will. And so you can't have a trust for minors because I tell my clients, I don't advise that you allow for your estate to go to your child when they turn 18. Bad idea. So a minor is not competent to inherit anything. So we have to provide for any minors in the will or trust. And so we can say, at certain ages, you get distributions, or upon certain events happening. So like going to college or some kind of secondary education is a lot of times a common requirement that we have for distributions to minors. Condition it on if they get married. That one I'd want to talk through with you more as my client.
I just wanted to say something that was like,
sure.
I wouldn't do that in reality.
But there are restrictions, or sometimes I might have a client where they know that the beneficiary may have addiction issues. And so maybe there's a restriction that, they have to, have clean UAs or some other kind of restriction before a distribution is made to them. So you can reach your hand from the grave and control, but there's limits as to how much you can do. And that's part of why, and I think this is going to go into some other questions that we have, is why you'd want to work with an attorney and preparing your estate plan, is that you can talk through these things, these questions that you have, and get actual, real answers and help you to think through, okay, I wanted to do this, but maybe it's not a good idea, or maybe we should do this instead, or to provide, recommendations as to what you should do. So yes, you can control the distributions, you can control from the grave, but only to a certain extent. At some point, we have to allow the funds to transfer to the person that we've named and allow them to have control.
Okay. That's fair.
Yeah.
Fair. So in what circumstances, like if you have a client come into you and they're like, oh, I need an estate plan, in what circumstances would you direct them towards a will versus establishing a trust?
Yeah. So sometimes clients will come to me and they already know which one they want. Maybe they've had experience with probate. Maybe they've had experience with the trust. But if they don't know, I kind of go over what we went over a few moments ago about the pros and cons, about the cost factor, the privacy factor, the probate factor, and then also the owning of assets outside of the state. So those are usually kind of the big considerations that we look at if a client doesn't already know what they want for estate planning. But no matter the size of your estate, we can do both options. We can do tax planning with both options. We can control distributions to children or other minors in both options. And so it's just a matter of how we're going to get to this end result. What vehicle do you want to take to get there? Is it a will or is it a trust?
So for folks who don't know, we are in Washington State.
We
right
probably
now.
should start with that. Yeah, we're in
Right.
Washington State.
So all of the things that we're talking about here right now are according to Washington State law.
Yeah.
And so in Washington, do we have a death tax, an estate tax?
There is an estate tax. And so what it is, it's $2.193 million per person. And so if the value of your estate at the time of your passing is under $2.193 million, then there's no tax. At the federal level, it's like 12, 13 million. Like it's pretty high up there. And so if you're under that amount, then there's no tax. We can do tax planning if you're a married couple to double that for the married couple to essentially about $4.386 million that we can exempt from any tax by doing some tax planning. So there is a tax. The tax table is about 10 to 20% of anything over that. So if for an individual, the value of your estate, let's say it was $3 million, the first 2.193 is fully exempt. The 800 or so thousand over that is what's going to be subject to the 10 to 20% tax.
I see.
Yes.
Okay. Well, I mean, I think that most of us are probably going to fall below that.
Right.
So,
and can I add one? I forgot to mention, I get a lot of questions on if there's an inheritance tax for the people who are receiving the inheritance. Is there a tax on them? And no, there is not, at least not in Washington State. So if the estate is under $2.193 million, there's no tax to the estate, and the individuals who are inheriting the assets do not have a tax either. Just wanted to make sure I added that there.
There's no tax regardless of how much the amount is.
For the people inherit, correct. There's just a tax on the estate if it's over that 2.193.
And only on the amount that's
over.
That.
Correct.
Right.
Correct. And that changes every year. It's reevaluated. It's stayed the same for the past, 3, 4, 5 years. It stayed the same, but it generally does go up. So we'll see when the next increase is.
Okay. Well, so you mentioned, we talked about trustees but we didn't talk about, or I think you might have mentioned an executor
In the wills, yes.
for the wills. Is the executor and a trustee sort of the same thing? Can you explain what those are relative to?
Yeah. And so in a will, you're going to appoint someone sometimes called an executor, sometimes called a personal representative. Those two are exactly the same, versus the trustee. And in your trust, it's going to be your successor trustee, to someone that you've named to serve after you. They're doing the same role. They are administering your estate. So your executor or your personal representative is administering it according to the terms of your will. Your successor trustee is administering your trust according to the terms of your trust. But with the will, they're only doing so through probate. But they're doing the same thing as far as administering. So liquidating assets, making sure debts are paid, filing any tax returns, and then making distributions to the named beneficiaries or heirs.
So 2 questions on that. First one is, how does one go about selecting or designating or appointing a trustee or an executor?
Yeah.
And then the second question is, if someone is designated as a trustee or an executor, can they also inherit, or can they also be a beneficiary of the trust?
Correct. So for the first one, as far as how do you pick, you can pick, anyone who's over the age of 18 that you know and trust to administer your estate. So if you're a married couple, you would name your spouse first. And then if you have adult children, if you feel that they would be, the right individual to choose, you can choose one of them. It doesn't have to be a family. It could be someone, a friend that's trusted. For some clients who don't have anyone to select, there are professional corporations that you can name as your executor or as your trustee. It does come with a hefty price tag. But for some clients, that is the best choice, or they don't have someone that they think is maybe financially responsible enough to serve in that capacity. So there are institutions that will serve in that capacity for you if you need to do so. And then the second question is, yes, your trustee or executor can be one of the heirs, can be one of the beneficiaries. So it can be one of your children, and even though they're going to receive a portion or all of your estate, maybe, they can still serve as the executor or trustee of your estate. That is fine.
All right. I always wonder about that. Like, if someone is an executor and they're like not too trustworthy,
right?
What happens then? But listen, I've been watching too much true crime.
Okay.
So that's what it is.
I mean, that's where we get to the fiduciary duty, right? And that you mentioned earlier, and that there is a duty imposed upon them, and if for any wrongdoing, there is liability for them from the courts and to the other heirs. So there are protections in place for the entire estate for any wrongdoing of a fiduciary, whether it's a trustee or an executor.
And then you can get that person removed, or
yes,
or they might be also held liable for any damages.
Correct.
To the estate.
Correct.
I feel like, again, too much true crime. And listen, a plug for another wonderful podcast, Sisters Who Kill.
Oh,
it's an entire podcast about Black women who kill people.
Oh, wow!
Just kill anybody, like kill their partners, kill their kids, kill other women, just whatever.
Huh?
But a very common thread is, okay, so and so is about to leave me, so I'm gonna kill him.
So but he can't leave me.
So he can't leave me, and before he can change the will and disinherit me. I mean, I've listened to at least 3-4 episodes on that topic.
Here in Washington, we have a slayer statute, so that if you kill someone, you cannot inherit anything. Okay. Even if you're named in the will, if you're the one that caused the death, then you don't get anything. Right. You're out.
I'm seeing a Sisters Who Kill. All you got to do is crossover episode right now in the making. If y'all are listening, this is my plug.
Yeah.
Okay. So if you kill somebody,
you're out.
You're out.
Even if you're in the will, even if you're the beneficiary, you are out.
Okay.
Yeah.
That is good to know.
Yeah. So just advance warning to any.
But actually, that's one of the ways that wills has changed over time. I didn't mention this before, is that previously in like the Middle Ages and even beyond that, it didn't allow for divorce and for changing beneficiaries. And now that's something that we can do.
Oh, yes.
It with ease. So
Yeah.
let's talk about that a little bit now. So let's say you have a client who was married
Right.
and is now divorced, and everybody's still alive. Everybody
Yeah.
made it.
Yeah.
But they want to change who gets what. Can you talk briefly about how they would do that?
I mean, they certainly need to do so immediately. Washington does have a statute that provides for that scenario where someone's divorced and they don't update their beneficiaries, but we don't want to go that route. Ideally, you would just update it upon a divorce happening. And so you're, contacting all your financial institutions where you bank, where you have any kind of investments, insurances, things like that, and updating those beneficiaries to remove the ex-spouse. And then for your will or trust, if you previously had one, you're updating that to reflect the divorce and removing that individual from that plan. Or if you didn't have one and you're creating one after a divorce, a will or a trust, then we are, providing for who you want your estate to go to upon your passing. But for anyone who is facing divorce or out of a divorce, you certainly want to ensure that all the beneficiaries are updated just to avoid any hiccups down the road if you were to pass of that not being straightened out.
But Washington does allow for...
There's a statute that provides if there was a divorce and the spouse was still listed as the surviving spouse as beneficiary, but it's just some additional hoops that we want to try to reduce for clients, right? So ideally, clients would update those things. As soon as, you have a divorce decree, we're updating all those items.
Right.
Yeah.
Just another one of the things to think
Just
about
another thing
after
that, yeah.
So what about the scenario where, again, two people are divorced, there was a child,
right,
and, the life insurance went to the beneficiary of the life insurance prior to the divorce was the spouse.
right,
Now, post-divorce,
yeah,
they want to change the beneficiary to the child.
right,
But a minor, can't inherit.
yeah.
So in that instance, would it make sense to just keep the spouse as the beneficiary, understanding that they would then hold that money in trust for the minor child, or
I would say no, would be my legal advice,
Mm-hmm.
But each person, knows their own relationships, with that ex-spouse and the amount of trust that is there. But you're right that a minor cannot inherit under state law. The problem is that most of these institutions where you have your life insurance are not based out of Washington, right? And so they don't tell you that you can't name a minor. They will let you name a minor. I have seen it many, many, many times.
Huh.
When a minor is named and the parent passes, there's a whole court guardianship that gets opened for that minor. It's a mess. It's expensive. It's very time-consuming and lengthy, and very limiting on what can be done with those funds from an investment perspective, and then release to the minor at 18. So please do not name a minor as a beneficiary, even if the company allows you to do so.
Yeah.
And so what I would suggest is that if we're doing your estate plan, in your will, in your trust, we're providing for your minor. We're probably creating a trust for minors that outlines how and when that minor receives those funds. That's what should be named as a beneficiary, is that trust, the minor's trust.
That's
So
interesting.
the funds go into that minor's trust. You've named someone to administer that trust on behalf of the minor, make distributions, and we always provide for health, education, the well-being of the child. But that way you can be assured that those funds are going specifically to your child and being provided for them, instead of hoping, wishing, trusting that the ex-spouse is going to use all those funds for the child. But again, it's going to be really a personal call and the amount of trust that's there. And, as the attorney, I don't know the dynamics of that relationship, right? So for some clients, naming the ex-spouse...
And there's a reason you don't do family law, right?
Right.
You're like...
I mean, so for some clients, the ex-spouse may be a perfect pick as a beneficiary, and the ex-spouse would provide for the child, and there's no issue. I usually see things when things go wrong, right? I see things when the bad things happen, and so I come to trying to put a plan together to avoid those things from happening and ensuring the funds are protected. So
That's fair.
that would be my advice. But again, it's going to be the client's call. I advise them as to what the options are, what the possibilities are, but it's really up to the client to decide what's best for them and their family.
That's fair. I mean, my ex-wifey and I amicably, very happily divorced, and we are the beneficiaries on our respective life insurance policies because we have a minor child.
Yeah.
And my way of thinking is this just seems easier.
Right.
I don't want to have to go through all that rigmarole. God
Yeah.
forbid anything happen,
Right.
to her, to me.
Right.
So that's just the way that we decided to work it. And I mean,
Yeah.
I think because we do trust each other,
Right.
that if we did get that money, that it would go
Right. For the
for
child.
her and
Yeah.
her upkeep.
Yeah.
So, but what you just said also is a good segue into my next question, which is, what are some of the common sort of issues or pitfalls that people will come to you to help them with?
So, the things that I guess the issues that I see when it comes to estate planning, is there not being a plan in place, right? There's no plan at all. And so the family is left to try to figure things out. Or there was a will that's a bad will. It's not a valid will. So maybe there's a form they found online, a DIY will, something that they just, did, on their own, and it doesn't comply with Washington state law. And so it's not a valid will. So you can do your own will. You don't have to have a lawyer do a will for you, but it has to be done in compliance with state law for it to be recognized as a valid will. And so sometimes I'll get wills that are just, they're not good wills. And so they don't comply with state law. So that's an issue. Again, dealing with minors who've inherited assets is a big issue. Having to open guardianships for them. So those are kind of the bigger issues that I see kind of come across my desk are those issues related to not having a plan, having a bad plan, or minors not being properly provided for.
So you mentioned an invalid will.
Mm-hmm.
What are some of the things that would make a will invalid?
Not having the witnesses. Is a big one. Usually, sometimes people will think that if it's just notarized, that's sufficient. It is not. It does require having two witnesses. There's a specific affidavit that needs to be attached that the witnesses sign that has to be included. That should be in there as well. Some of the language that I've seen in a will, it can't be achieved. Like what the person wrote versus what we can actually do. The two don't mesh. And so usually it's either the language of the distributions or it's not executed properly. It's not signed by witnesses properly are usually the two big issues that I see with DIY wills.
Okay.
Yeah.
So that now is a great segue to my next question. And this is, we have Hollywood on strike, all this other stuff because of AI. Now, I know that people can go to like LegalZoom and these other online legal websites, and they'll have a template, and you could just like cut and paste your information in, and then boom, you have a will.
Yeah.
So what do you think about that? Like, what are the risks and the benefits of AI, an AI generated will or an estate plan versus a person?
Yeah. So, a will that you'll get, off LegalZoom or any kind of those websites, like the template itself complies with state law, right? And they give you instructions on how to fill it out, how to sign it properly. You have to make sure you follow those instructions, right? Sometimes I see where the template is good, but the fill in the blank portions were not done correctly. They didn't follow the instructions. So that's an issue. But then also, sometimes clients, you don't know what you don't know, right? And so you may think that you can do something or something will work out, but actually it's not in compliance with law. It's not actually going to work. And so, having a trusted legal, an attorney or legal advisor that you can go to ask these questions and put a comprehensive plan in place that actually reflects what your wishes are and where you have that guidance and advice as to what you can or cannot do is really where the value comes in of having an attorney assist you with your estate plan, whether it's a will or trust. So again, like those DIY, those AI options usually the templates are good. It's just the execution of them, the completion of them, and then not knowing that what you're trying to do in your will, can't be done or is not practical for your family. Sometimes I have communications with clients, where we're consulting about their will and what they want. And then, I raise the other side of it. Like, well, what about this or what about this? Because this is going to happen. And they haven't thought that far in advance just because they don't know. It's just, and so having, an attorney to kind of guide you through that process, because yes, there's a cost savings with the do-it-yourself will, but we're talking about maybe your house. Maybe we're talking about your minor children, your families. We're talking about, bank accounts or life insurance. Like, we're talking about a lot that's at stake here. And so I understand, wanting to save money on it, but if you do it wrong, the cost far exceeds what you would have paid to have it done correctly the first time.
And by the time there's a problem, you
You're
might
gone.
already be
It's too
in
late.
the ground.
Yeah,
and everyone else is dealing with it.
your family's dealing with the
Right.
mess and picking up the pieces and going to court.
Yeah.
Yeah.
And for your clients, do you support them through the probate process or?
Yes.
Okay, so that's
Yeah.
another thing that you wouldn't necessarily
Right.
get with an online will is.
Right. And I mean, you can take your online will to, any probate attorney and, assuming they accept, they're willing to take it on, they can help you with it. For a lot of the families I work with, I think for the family, knowing that I actually knew the person who passed away kind of gives a sense of, maybe, comfort and, assurance for them to work with me in the probate, and that I did know this person. I did meet them. The decedent, trusted me.
And you knew what their intentions were.
I knew what they wanted.
Yeah.
I have my notes and, I know what the intention was. We have a good will or a good trust in place. And then also with my estate planning, beyond just your legal documents of your will or trust and your power of attorneys and things, I provide what we do is a binder that has guidance for the family as far as what to do when someone dies, who to contact, who to call, how to get a death certificate, how to contact Social Security. And then also we have, forms and the binders for our families of, where did you bank? Where did you have life insurance? Who's your CPA? Who's your financial advisor? Like, 'cause we used to be able to tell clients, years ago, like, just check the person's mail who passed away and you'll be able to find out all these things. We'll get statements in the mail. That's not the case anymore. You don't get that in the mail anymore. And so, having that information, just having this one binder that has a comprehensive resource for everything your family needs to know is really one of the best gifts you can leave to your family.
And that's something that people can probably do for themselves
Yeah.
also.
Yeah.
That's something to think about.
Yeah, is that if you, are putting, your own plan together, list where you bank, list where you have investments, list, your cell phone passcode. Like, you can't get that when someone passes away. It's virtually impossible. And there's so much in that phone, whether it's photos or important information, like, now I tell my clients, now when I do this binder for you and we have all this in here, you can't lose this binder. You cannot lose this binder, right? You have to keep track of this binder. You can't just have it on the shelf somewhere, right? And so wherever you keep these important documents and important information, it needs to be somewhere safe and secure, but also that the important people that you've named have access to. So if you have it in a safe at home, make sure they have the combo. If you have it in a safe deposit box at a bank, make sure that they're named on that safe deposit box at the bank to have access to it. So that's the caveat I give my clients when we deliver binders is that,
That's a good pro tip. Yeah, because I could see myself shoving it away in some box and then not remembering where it was.
Yeah, we can't do that.
Yeah,
we can't do that.
That's bad news.
Yeah.
So you said that, the AI, there's probably going to be a cost savings. About how much, or like a cost range, if you could,
Yeah.
how much is it for an estate plan, like an average estate plan?
Yeah. So it depends. Favorite lawyer answer, right?
Right.
But so I do provide a range. I have it on our website, which I think we'll probably share in the show notes. But so for an individual, a simple estate plan with your will, power of attorneys, and directives is $795. As of right now, March 2024. Right. And so, in the future it may change, but that's the current price. For a married couple, it's $1,395 to have that complete package with a community property agreement if it applies. For your trust package for a revocable living trust for an individual is $2,500. So again, it's more expensive than the will package. For a married couple, it's about $3,000 for a married couple's revocable living trust. And then if we're doing complex, distributions, if we're doing tax planning, it could go up from there depending on what we're doing. But that's kind of where we're looking at for an estate plan and kind of what the costs are looking like currently.
And if someone, and you mentioned that the cost for the will was less expensive than the trust, but let's say someone went the will route.
Yeah. How
much is the probate process?
It's going to depend on what all the assets are. With a pretty simple will, maybe there's, a home that needs to be sold, possibly. I would say probably $4,000 to $6,000 for the probate costs. And that's, again, that's assuming, simple, no objections, no fights among family, right? One piece of real estate. If it's more complicated, if we have a lot of real estate or other issues, it can go up from there. But with all of our, just because I mentioned any kind of disputes, all of our wills, all of our trusts, I include what's called a no contest clause. Mm-hmm. So that means if anybody contests something, if anyone disputes your will, they're out. So it helps to disincentivize disputes among family members or whoever you've named.
Wow. Okay.
Yeah, it's a little harsh, but
Darcel, don't play. You're going to shut up and take this money.
Because my clients, they don't want that, right? Like they want, what they put in their will or trust. They put it there for a reason. Mm-hmm. Maybe the family doesn't like it, but that's what the client wanted. So this is what the plan is. If you dispute it, you're out. You get zero. So it really helps to scale down any kind of disputes.
I know, that's right.
Yeah.
So it seems to me, though, that given what you just said about the probate process, the trust might actually be the less expensive
overall
option.
It is.
Overall
it is.
Yeah.
But for clients, it's the initial out of pocket, right? It is, the factor. For some clients, they tell me, well, I won't be here, so I don't care. Like my estate can pay for it later. Like, they're looking at the out of pocket to them currently. So, and a will is still a very good plan. Like there's nothing wrong with the will. Like I don't want anyone to have the misconception that, a will is bad or that it's not a good plan. It's still a good plan. And there's other states where probate is very burdensome. California is where it's notorious, where everyone wants a trust and they don't want a will there because of the time. And also I believe the fee structure is based on a percentage of your estate value. So like if statutory is a certain percentage, so it can get very expensive. Yeah. That's not the case here in Washington. So probate is not a bad process in and of itself. It's pretty streamlined here, but it does add an expense. It does add time. And again, you don't have the privacy, you have the court involvement. So those are other factors to consider, but probate is not bad. A will is not a bad option at all.
And with both of these options, we haven't really touched on this yet, but with both of these options, you can address those sort of end of life issues, right? Like, do you want to be cremated?
Yeah.
Like, what are the terms? Like, how do you want your funeral to look? Do you not want, Uncle Eddie there? Like, whatever. Like, you can include those types of things in both instruments, right?
Yeah. And so and those are actually separate documents. So it's called a directive for remains as far as, what your options are for your remains. So if you already have prepaid arrangements, if you have already prepaid for a burial plot, or you have other, some clients want cremation, some clients want burial, some clients, if you're a veteran and that you're covered by the VA, here in Washington we have composting as an option for remains, and so there's a wider range of options. So we do include that directive of both wills or trusts, and then also beyond that, we also have what's called the physician's orders forms or a living will, where, what you do or don't want if you're in a permanent unconscious state, right? And so we make those elections as well, which helps guide your family so they're not having to make those decisions at that point in time. You've already decided for your family. I do want this. I don't want this. That way it takes, again, another burden off your family from having to decide, what to do, in that situation.
And it would be the trustee or executor that is going through and making sure that those wishes are being fulfilled? Like who would manage that?
So you're naming someone.
Okay.
So you're naming someone. And so for your will or your trust, at that point in time, you've already deceased. And so for this living will or directed to physicians, it's while you're still living, but you're not coming, there's no hope of resuscitating you, right? And so what kind of elections do you or do you not want? For most clients, for most clients, they want, just relieve me from pain. I don't want any pain, but otherwise, if I'm in a permanent unconscious state, don't keep me, here intubated for, months on end. Like, let me go. But you're making those decisions. So your family's not having to decide, to let go or not. You've already told your family, this is what I want. This is, what my decision is. So, these are not the most pleasant conversations to have.
Right.
Which is why a lot of clients, put off doing this. A lot of my clients will come to me like, I've been wanting to do this for 20 years now, and I haven't gotten around to it, because nobody wants to talk about this. It's so morbid, right? But it's like, but then you're leaving it to your children to decide, or your other family members to decide this for you when they're already going through these emotions of, of whatever's, happening at the time. And so it's just really putting a plan together. And I like having my clients put a plan together.
Yeah, it does seem like a kindness to those left behind.
Right. Yeah. So, it's not the most pleasant. And we do what we can to make it as easy for our clients as possible. But there are some difficult conversations that we have to have about making some of these decisions. Mm-hmm. And again, whatever you decide, if you change your mind later, you can change your mind later. As long as you're competent to change your mind, we can change it later. So it's not set in stone forever.
All right. Well, thank you for all of that. I definitely going to need a pick-me-up after this session. But okay, so the key takeaways I've picked up from our conversation. Everyone should have an estate plan.
Yeah.
Of some sort, whether that be a trust or a will or something. There should be a plan.
Yeah, and it doesn't have to be complicated. It could be a simple plan. That's fine.
Yeah.
I don't want to complicate. I'd rather it be simple.
Yeah.
Because
then it's easier to actually put into effect.
Yeah. And for me, with our estate planning, we provide like summaries of like, this is what your estate plan says. This is what it means. Because a lot of clients will come to me with an estate plan from somewhere else from 20 years ago, and they have no idea what any of it means. It's all this legalese jargon, and they're just like, I don't even know. And so, one of my big goals with our estate plan is that I want you to understand your own plan. I want your family to be able to understand what the plan is and what it says. And so we try to, there's certain things we have to have in the documents, right? But we try to provide summaries and kind of outlines of this is what it is, this is what it means, this is how it works.
Okay. My second takeaway is you don't have to be wealthy to have an estate plan.
Yeah.
And then my third takeaway is seek professional advice.
Yeah.
Maybe even if you do a legal Zoom will, maybe take that extra step and have an attorney review it.
Yeah. It depends on the attorney. I tell clients it takes me more time usually to review and fix your bad will than for me to just do it right in the first place.
That's fair.
So just to be honest, that, sometimes people come to me and they have these documents that they did themselves. And they're just like, can you review these and, let me know if these are good or not? Well, it's going to take me 2 or 3 hours to review these DIY and tell you what's wrong with them. Or I can do it in the first place and do it correctly the first go round for less money.
Yeah, that makes sense.
So just a heads up about that is that it usually takes me longer to try to go through a document and redline what's wrong with it.
Yeah.
So.
Okay.
But yeah.
Good note.
Yeah.
All right. Well, anything else you'd want to add there?
Gosh, no, I think your takeaways, were spot on. You don't have to be wealthy. You don't have to have a lot of assets. And, having an estate plan doesn't have to be difficult or complicated. We try to make it easy for you. And it's really one of the best things you can do for your family. I think that's really kind of the big takeaways.
Awesome.
Yeah.
So, aside from this conversation, what we usually like to leave people with are some resources. So do you have any resources for people who might be lower or middle income that might need some help with an estate plan?
Yeah, so there are some like neighborhood legal clinics, like through like the county bar association, where they will have maybe once a month, or sometimes it could be a traveling clinic where they will do wills and plans, and it usually is like income limitations as to qualifying for it, because it's a free program. And so I think what I'll do is that I'll provide those. We can include it in the show notes for
Wonderful.
links to those resources for people. If you qualify, there are options out there for free, maybe reduced cost services as well for estate planning. So we'll make sure we get those posted for everyone.
All right, wonderful. And then the plug. Where do the folks find you?
Yeah. So again, I'm Darcel Lobo. I own DAL Law Firm in Normandy Park, which is kind of by the airport, by SeaTac Airport. So the website is dallawfirm.com, which is DALLAWFIRM.com. So we have the website there and resources there. We have a blog there that kind of goes over a lot of these estate planning questions. I make YouTube videos talking about this as well for estate planning, which is just at DAL Law Firm. Or you can also call or text us. The number is 206-408-8158. But again, I'm only licensed in Washington State. And so if you're outside of Washington, I would love to help you, but my license doesn't allow me to do so. So I would recommend that you contact your county or state bar association, whatever state that you're located in, if it's not Washington.
All right. And we will have Darcel's firm information in the show notes as well, so folks can find her if they need her. I feel like I need you. I have not addressed my estate plan since my divorce. So yeah. Anyhow, thank you for your time.
Of
It
course.
was great seeing you.
Yeah, thanks for having me.
Yeah.
Very good.
Over and out. All right, this wouldn't be a legal podcast without a legal disclaimer, y'all. So remember, seek legal counsel for your specific situation and in your specific jurisdiction. Thank you all for listening. And remember, if you don't get the system is gonna get you. See y'all next time.